Hi, this is Sujan Budathuki, student ID number TNE5009, currently studying Bachelor of Professional Accounting. In this video presentation, I'll be discussing the summary report of group assignment, which was assigned to us, and I'll be discussing the part A question, which was related to contract law. If Frank is caught while retrieving his vehicle from the automated parking garage, parking lane parking may try to utilize the exemption clause to avoid responsibility for his medical bills and other damages. According to Houghton versus Warren, 1936, 54 CLR 656, exemption clause, also known as exclusive clauses, are enforceable under Australian contract law, whether or not such provisions are properly integrated into the contract and whether or not they cover the particular circumstances of the claim determines whether or not they are valid and enforceable. The exemption clause need to have been brought to the parties' notice prior to or around the time the contract was created in order to be enforceable. The crux of the matter is whether or not Parkland Parking Pool has have given Frank fair warning about the exemption provision before he signed the contract. The ticket's reference to the terms and conditions posted on the premises is indicative of Frank's possible knowledge of the exclusionary provision. This notification, however, will only be effective if Frank was had a sufficient time to review its content before committing to them. The exemption clause's seeming lack of visibility may be called into doubt if it appears in fine language on the ticket or is posted on a pillar. The court might look at whether the provision was prominent enough to catch frank notice. I am passing the torch and the PowerPoint to my capable teammate to take it from here.
Hello, lecturers. My name is Shuyuan Wang. My student number is CEN5003. I'm gonna discuss whether mention will be liable for negligence in this case. So, Ellis must first show that Mason was obligated to keep her safe. In Australia, the standard of care is established based on how likely it is that damage might happen. The key issue in this situation is whether Mason won't illicit the duty of the care given the circumstance as the motorcycle driver. And the first case is from the Donovan vs. Stevenson. There is a publication from 1932. And the master may have owed Ellis a duty of care because she was riding his motorcycle and he was responsible for her safety. Ellis might have anticipated the potential of an accident. They would have insurance given that Mason was having problems controlling the motorcycle. So Mason's failure to keep in control of the motorcycle indicates that he may have violated his duty of care to Ellis by continuing to ride while drunk. A sensible person in Mason's position would have Ellis stayed from driving or looking for another mode of transportation, given the possibility of harm to the passenger. And Ellis must show that Mason's carelessness was the actual and direct reason for her damage. Proof the factual causation is evidence that the damage would not have occurred except Mason's breach. Mason's violation must have been forcible in order for it to be held accountable in legal terms. This note as the proximate case. So if Ellis can demonstrate that Mason's drunk driving test the crash and her endurance, she might be able to satisfy the need for causation based on the provided facts. It appears to have strong case negligence against Mason. He complied with the duty of care. He owns Ellis as a passenger, is caught into adopted by her view of his drunk driving. So finally, it's likely that Mason would be found be negligently liable in this case if Ellis can demonstrate these three elements of the negligence before making a judgment. The court would have to consider the evidence and apply the Australian negligence law. This is my presentation. Thank you for listening.